hope you're all doing well. My name is Dikshika Tripathi and I work as a human rights activist for AIHRA. So, today I will be explaining the concept of inheritance. What is inheritance? So, when a person dies, he leaves his property behind. So, the property that he leaves, it is passed on to his legal heirs, and this passing on of property is known as inheritance or succession. So, there are two types of succession. First is testamentary, and the second is intestate. Now, as the word testamentary suggests, it is a succession which is based upon the will of the deceased. So, what is a will? A will is an oral or written formal agreement by the deceased as to who is to supposed to get what and how much of the property. Now, as per Muslim law, a Muslim man can leave a will for one third of his property, and the remaining two third has to be intestate and governed by the rules of Muslim law. Secondly, now it is important to know which property can be inherited. Sorry. The word no specific difference means that unlike Hindu law, Muslim law sees no differentiation between immovable property and movable property. Therefore, they are both treated alike and they are kept under the same category while distributing them. And the total worth of the property is determined only after the appropriations like death and the expenses of the funeral or burying are deducted from it. Now that Now that we're clear on the concept of what is inheritance and what can be inherited, let's take a look on how the property is distributed. So there are two modes of distribution. First is per capita, which is mainly practiced by the Sunni Muslims, and the second is per strip dispersion, which is mainly practiced by the Shia Muslims. So let's take an example. Suppose there is a Muslim man A. He has a son B, and then he has two more sons, X and Z. So now B has a son C and Z has a son W. So when we talk about per capita dispersion, it will be treated that all these five legal heirs are individual heirs and the total property will be divided amongst these five of them. But in per strip dispersion, this will be regarded as one strip and this will be regarded as one strip. So in total there would be three strips. So the property will be distributed amongst these three strips. I hope that's clear. Moving on, there are classes of heirs. So Shia law recognizes two classes of heirs, that is the sharers and the residuaries. These two. And if even after this stage there is some property remaining, then it will go to the government, that is estate. However, the Sunni law recognizes these all three categories. So first the property will go to the sharers, if it remains it will go to the residuaries, and even after that if there is some property remained it will go to the distant kindred, and even after that if there is some property it will go to the government. Now here, sharer are the people who are the closest relatives of the deceased person, and then the residuaries are who are a little further relatives, that is a relative of relative, or you can say nephew, niece. And now the distant kindred are the distant relatives. An estate is when a property is not inherited by anyone and it is passed on to the government due to lack of legal heirs. It is known as estate. It is spelled as ESCHEAT. Moving on, when we talk about prescribed share of sharers, so the Sunni law recognizes 12 sharers, 8 female and 4 males. So now when we see these shares, everyone has a fixed share. However, some of these relations seem to have two shares, two different ratios. What does that mean? So when we talk about husband, if he does not have any children, that is he and his deceased wife do not have any children, then he will get half of the property of his wife. But if they do have some children, then the husband would get one-fourth of the property of his deceased wife. The share of the father and grandfather is fixed at one-sixth, no matter what. Then there is wife. She will get one-fourth of the share of her husband's property, that is her deceased husband's property, if they don't have any children. However, if they do have some children, then she will get one-eighth of the property. And if there are multiple wives, then this one-eighth would be divided amongst them. Say if a man has two wives, then both of them would be getting 1 by 16th of the property of the Muslim man who has deceased. Now, when we talk about daughter, if there is one daughter, she will get 1 by 2 share. However, if there are three daughters, or that is two or more, then all of them would get 2 of 2 by 3, and this 2 by 3 would be divided equally amongst the daughters. And similar rule is applied for son's daughter, that is the deceased's grandson. Now, we shall talk about the rules of exclusion of the heir that is who is entitled for a property under Muslim law. Here the first topic is homicide. Homicide means whoever murders the deceased or whoever has any role in the death of the deceased, then he will not be entitled to the property. Here the rules are a bit different when it comes to Shias and the Sunnis. When we talk about the Shias, they exclude the deaths which are unintentional. For example, let's see there is a Muslim man A and the cause of his death is his son B. So if B has intentionally caused A's death and they are Shia Muslims. So in case of intentional death, he will not be entitled to any property. However, if the death was caused due to an accident or any unintentional accident, any incident. So B will be entitled to his property, that is A's property under Shia law. But when we talk about Sunni law, no matter what, even if there is no intention, B will not be entitled to the property of his father if he has in any way caused the death of his father. The next rule of exclusion is about illegitimacy. Now, when we talk about illegitimacy, it means that a person or the child has been born out of wedlock. So, when we talk about this, if a child's mother has been deceased, if an illegitimate child's mother has been deceased, then he can claim her property. However, an illegitimate child cannot claim the property of his father because it is not very obvious to prove the fatherhood. The third important rule is the difference of religion. So when we talk about difference of religion, the main issue that comes up is conversion. When does conversion become a rule for exclusion? So let's say A is a father, a Muslim man, and he has his son B. So if B converts from Islam to say Hinduism or Buddhism, then he will still be entitled to receive the property of his father and he will still be considered as a legal heir. However, his son, that is C, or A's grandson, won't be entitled to the property of A. However, if let's see the father has converted from Islam to any other religion, then this line of legal heirs would end right here and B won't be entitled to the property of A. And the next and the last rule is regarding exclusion of daughters under some customs or statutes. So this rule is not followed everywhere, just a few places. For example, the Gujars and Bakarwals of Kashmir. In these regions, there is a custom that the daughters cannot inherit property in presence of any male descendant of the grandfather. However, if there is no male descendant, then the daughter can inherit the property easily. So with this, we come to the end of the topic, and I thank you very much for listening to me patiently. And if you have any doubts, then you can feel free to ask me. And please do ask me if you have any queries.